And now, Legal Perspective with Nick Clekis.
Dealing with a workplace injury is challenging enough without having to navigate the often complicated world of workers' compensation. To better understand this process, we are joined by Jackie Drescher, attorney with Clekis Law Firm. Jackie, great to have you with us today.
Thank you.
And what are the most common challenges that people run into when filing a workers' comp claim?
Well, when they come to me, it's usually because there's some issue in the case near the beginning, whether the employer has not reported the claim, or it's been reported but their medical care is not being approved, or at least not approved in a timely manner. Then those are some of the reasons they would come to me. Or if they're not getting paid, compensated while they're out of work.
Okay, so when you file a claim, there's plenty of different reasons why that claim could get denied or the employer could deny the claim. What happens when an employer denies a claim?
Well, the first thing I do is, try to figure out why they've denied it. Sometimes you don't know. But I look at the claim and see if I think it was erroneously denied. And if I believe they should not have denied the claim, then I'll file for hearing. And then the commissioner will determine whether or not the claim is compensable.
So what are some of the reasons why an employer could deny a claim?
Well, there are lots of reasons. One is when the employer asserts that the employee is an independent contractor rather than an employee, because obviously you're covered under workers' comp if you're an employee.
Not if you're an independent contractor.
No, not if you're independent generally. And if you're an employee, some employers think if they 1099 the employees at the end of the year rather than providing a W-2, that they are independent. But that's just one of the tests to determine whether you're an independent contractor or an employee. There's actually several things you look at. One would be the method of payment, which is the 1099 or W-2. Another is the right to control, the ability to control, which is how much direction the employer provides to the employee. An independent person has sets more of their own schedule and their daily events of what they're going to do, where the employer does not tell them exactly the order. Like, for example, if you're a delivery person, the order that you deliver the packages, where you go, how you do it, and what you wear. The more control the employer has, the more likely you're an employee. Okay. Then another prong is the right to fire. And in South Carolina, we are employees at will. And if you are an independent contractor, sometimes there's a clause in that agreement where there might be a penalty if they let you go early. But if you're an employee, most of us are employees at will, and we could quit or we can be fired. And then the other thing is who furnishes the equipment. If you're doing a job and your boss provides the truck and the tools and everything you need to do the job, then it's more likely you're an employee. Where if you provide your own materials, and it doesn't have to be a trucking type of situation, it could be in an office as well. The more your employer provides for you, the more likely you're an employee. So we look at all of those things in totality to determine whether or not someone is an employee versus independent contractor.
And now, speaking of that, the way that an attorney can help in a situation with a workers' comp claim, can you kind of expand on why it is so important to seek the help of someone who really understands how this all works? Well,
first of all, it's a lot easier to prevent problems than to correct them after they occur. And one thing we're able to do, we want you to get your medical treatment in a timely manner, and sometimes that's not being done, and we can file for hearing to expedite that, because that could actually delay your recovery. If you're not getting income as you go along, and temporary total disability is the method of payment through the insurance company when you're out of work. That generally is 2/3 of your average weekly wage, but you don't pay taxes on it, so it's supposed to be roughly like your take-home pay, but it's not exact. But if the employer is not paying that, then you can't get by on a day-to-day basis. But all of the issues that you have in a comp case, we can help to prevent problems before they occur. I've had some situations where the employer tells the employee, you're on light duty, we don't have anything for you, come back when you're well. And then they don't really convey this to the insurance company. So the insurance company says, well, we're not paying your weekly wages because you were light duty and you should have gone and done that work. And unless we get, if we get an honest employer that says, yeah, I told them that, then that's great. But if you get someone that says, well, they just weren't here, then we have trouble proving that they were entitled to the TTD if we're facing it after the fact. But if I'm there on the front end, I'm making sure that that's taken care of before it becomes an ongoing problem.
Jackie, how can someone get in touch with you and Clekis Law Firm if they are looking into filing a workers' comp claim?
Well, we have 2 locations to serve you. One is in is North Charleston, 2850 Ashley Phosphate, and one is downtown, 171 Church Street, Suite 160 here in Charleston. Or you can call us at 843-9000000. That's easy to remember. So we'd love to hear from you. And calling is free. We're happy to give you any advice you want, and we work on contingency fee only, so you don't have to pay an hourly fee. And we're happy to help and prevent these problems and make sure you maximize what you're entitled to under workers' comp.
Absolutely, Jackie. Thank you so much for joining us today.
Thank you.
We're back after this.
This has been Legal Perspective with Nick Clekis.